Do we go into the weekend? So we have yet to hear from the court what the plan is.
Absolutely. Shimon, stick close. I appreciate it, man. Thank you. Now let's turn to Georgia in the trial of 3 men accused of killing Ahmaud Arbery. The Arbery family attorney telling CNN that an attorney for one of the defendants tried to reach a plea deal for their client, and the prosecution declined. Closing arguments are set to begin Monday. CNN's Martin Savage is live at the courthouse there on this one. What are you learning about this plea deal request, Martin?
Good morning, Kate. Yeah, this is another weird one here. What we know, Lee Merritt, the attorney that represents Wanda Cooper Jones, says that he'd been in contact with the prosecution. The prosecution says last night Kevin Goff, the attorney for William Roddy Bryan, came to them and wanted to make some kind of a plea deal. We don't know what the deal was. We don't know the details. We do know that the prosecution rejected it. Wanda Cooper Jones, going into court today, also said, yes, it's true. And then we had Kevin Goff coming into court today, and of course he was peppered with questions. Take a listen.
Let me get through.
Mr. Goff, did you offer a plea agreement?
The plea deal report? That's bull.
What's bull?
What exactly are you referring to?
I'm not getting into it with you. Denied. Thank you, sir.
Denied that you asked
What do you think the fate of your client is?
Denied. I don't know what y'all talking about.
Now, that is read into by a lot of people as implying that the defense might be very fearful now of their case after everybody has rested. We'll have to wait and see. Closing arguments, as you say, taking place on Monday, could be up to 6 hours or more. Today, they're going over the charges that will be explained to the jury then. Kate?
All right, much more to come. Martin, thank you. Joining me now is CNN senior legal analyst Elie Honig and Bernarda Villalona, a criminal defense attorney and former prosecutor. Elie, can we just start what Martin was just laying out for us? What do you think of this, what the family attorney for the Arbery family says was an ask by one of the defendants for a plea deal, and a plea deal that prosecutors declined?
Yeah, Kate, so this does happen sometimes, very rarely, but it happened to me a handful of times. While a jury was out deliberating, a defendant's lawyer said, hey, would you be interested in a plea? Now, my answer was always no. As a general rule, as a prosecutor, you do not take a plea while the jury's out if you have any kind of confidence in the case that you've just put on. I think the natural inference we draw is that there's some concern by this particular defendant about the strength of the government's case against them. And I also think it's important to note, this lawyer represents William Bryan. Of the 3 defendants in the case, the 2 McMichaels and William Bryan, the evidence is the weakest against William Bryan. He was the guy in the follow car, the neighbor. So it's interesting that he, of the 3 defendants, if true, was interested in pleading.
I actually was, I mean, with my, no legal basis to have this thought, Bernardo, was actually surprised that if this request came from William Bryan. What do you think it says about what they think of their case?
Absolutely. I'm not surprised that this request came from William Bryan. I am surprised at the timing of this request, because I would have thought that he would have made this request prior to the trial actually starting. But the writing's on the wall for him. He saw all the evidence that's been presented, and the evidence has shown that his client is guilty. So he has a high likelihood of being convicted. So now he wants to limit his exposure. So I'm not surprised at the ask. The question will be, what was the exact ask? What number was he looking at?
Good point. Elie, can we move over to Wisconsin now? Because I do want to ask you, as the Rittenhouse trial is now, the jury is deliberating. Late yesterday, as Shimon Prokupecz was laying out, the judge agreed to one juror's request to take the jury instructions home. What's your reaction to that?
So first of all, that never happens. Like Shimon said, I've been part of many, many trials. I canvass my friends here. Nobody's ever heard of even this request being made. Now, on the one hand, it suggests to us that the jury is really looking very carefully at their legal instructions, which is a good thing. That's what they're supposed to do. I think it was a risky decision by the judge to allow them to take the jury instructions home, because the whole point of a jury deliberation, the judge tells them over and over, is you are to only consider the evidence in this courtroom. You are to only deliberate back there in that room. You are not to consider anything from the outside world, anything you may have seen or done or heard. And now he's essentially letting them take home homework, which in my experience is completely unprecedented. So it's an interesting move. I think it gives us a little bit of insight into where the jury's focused. They're focused on the right thing, but I would not have let them take it home if I was the judge here.
You know, and the way it kind of played out, according to the reporters that were in the room, Bernardo, was that once the jury had left the room, the defense team, after this had kind of been established and the judge seemed to give the go-ahead, the defense team said that they were concerned that it could lead to the jurors looking up definitions or doing research on their own. That's how it was described. Why is that a concern for the defense?
So it's a concern for the defense, and if there's a conviction in this case, it also will be grounds for appeal. This is unprecedented that a juror is allowed to take the jury instructions home. The jury deliberation is only to take place when all 12 jurors are gathered together. If one steps out to use the bathroom, deliberations must cease. Also, take it a step further, jurors aren't allowed to take their notes home or outside of the courthouse. So for a juror to be allowed to take the law that they have to apply to the facts, the crucial piece of deliberations home, I think it disrupts the sanctity of jury deliberation. So you don't know what they're doing, talking to other people, researching, looking at the news. You just don't know. And I think the sanctity of jury deliberation has now been interrupted.
Real quick, I mean, closing arguments, Allie, as you and I discussed, were so important in the Rittenhouse case. Closing arguments are set to begin on Monday in the case against the men who are accused of killing Ahmaud Arbery. What do you think closings are going to look like next week over in Georgia?
Yeah, so I think the prosecutor is going to focus on two key points. Number one, this whole defense of citizen's arrest is nonsense. The reason they were pursuing Ahmaud Arbery was not to place him under citizen's arrest. It was because they saw a young black man jogging through their neighborhood and they aimed to do him harm. And there's evidence to support that. There's plenty of evidence to support that. The second piece is that Travis McMichael's testimony happened during the struggle immediately before the shooting is false, because Travis McMichael tried to tell this jury that Ahmaud Arbery had his hand on the gun. However, McMichael told the cops back when this happened that he did not know if Arbery had his hand on the gun. That's a huge problem for the defense, and I look for the prosecution to try to really slam home those two themes.
Yeah, it's great to